Welcome, my fellow attorneys, to the National Bankruptcy Academy video series. I'm your host, Robert Schaller, an attorney with over 34 years of experience and a registered certified public accountant. Today, we'll be discussing the statement of compensation with a line-by-line analysis with real-world commentary. I hope you enjoy this video. Every Chapter 7 attorney must file the disclosure of compensation for services rendered and reimbursement of expenses. An attorney's disclosure of compensation is officially titled Official Form 2030, Disclosure of Compensation of Attorney for Debtor, but the form is commonly referred to as simply the Statement of Compensation. Note that the debtor does not file a separate statement of compensation paid. Instead, the debtor merely has to disclose the compensation paid within 1 year pre-petition to the attorney in the Statement of Financial Affairs on line 16. The debtor must also disclose compensation paid within 1 year pre-petition to anyone else acting on the debtor's behalf who's promised to help the debtor deal with creditors or to make payments to creditors. That disclosure is also in the Statement of Financial Affairs, but on line 17. The Bankruptcy Code states, quote, any attorney representing a debtor in a case under this bankruptcy title or in connection with such a case, whether or not such attorney applies for compensation under Title 11, shall file with the court a statement of the compensation paid or agreed to be paid if such payment or agreement was made after 1 year before the date of the filing of the petition, for services rendered or to be rendered in contemplation of or in connection with the case by such attorney, and the source of such compensation paid, unquote. Now, the bankruptcy rules state something different. They state, quote, every attorney for a debtor, whether or not the attorney applies for compensation, shall file and transmit to the United States trustee within 14 days after the order for relief, or at another time as the court may direct, a statement required by Section 329 of the Code, including whether the attorney has shared or agreed to share the compensation with any other entity. The statement shall include the particulars of any such sharing or agreement to share by the attorney, but the details of any agreement for the sharing of the compensation with a member or regular associate of the attorney's law firm shall not be required. A supplemental statement shall be filed and transmitted to the United States trustee within 14 days after any payment or agreement not previously disclosed, unquote. The bankruptcy court has the power to review the compensation paid to any attorney in determining the amount of reasonable compensation to be awarded to a professional person. The court shall consider the nature, the extent, and the value of such services, taking into account all relevant factors, including the time spent on such services, the rates charged for such services, whether the services were necessary to the administration of or beneficial at the time in which the service was rendered to the completion of a case under this title, whether the services were performed within a reasonable amount of time, commensurate with the complexity of the case, importance, and nature of the problem, issue, or task addressed. Also, with respect to a professional person, whether the person is board certified or otherwise has demonstrated skill and experience in the bankruptcy field, and whether the compensation is reasonably based on the customary compensation charged by comparably skilled practitioners in cases other than cases under this bankruptcy title. If the court determines that the compensation received exceeds the reasonable value of any services provided, then the court may cancel the attorney-client agreement. Alternatively, the bankruptcy court could order the return of the payment to the extent excessive. The payment would be returned to the bankruptcy estate or the entity that made the payment as directed by the court. Now, let's turn our attention to this bankruptcy form with a line-by-line analysis with real-world commentary. I hope you enjoy the video. So now let's look at Official Form 2030. Up in the corner, you notice that it says B2030 and in parentheses, Form 2030. And it starts with the normal top of every document. What is the United States court in which the case is filed and who is filing? So here it says the United States Bankruptcy Court, and we're going to fill in the Eastern District of Virginia. Next, we're going to identify who the debtor. In this case, it's George and Martha Washington. Next, the case number. And we're going to assume in this particular case that this statement was not filed with the petition, but was filed after the petition, and there's an actual case number. So let's enter it. And of course, we're filing a Chapter 7 case. Now let's scroll down. First, we're going to note the actual form title. It says Disclosure of Compensation of Attorney for Debtor. Let's look at paragraph 1. Paragraph 1 states, quote, pursuant to 11 U.S.C. section 329A and Federal Bankruptcy Rule of Procedure 2016B, I certify that I am the attorney for the above named debtors and that compensation paid to me within 1 year before the filing of the petition in bankruptcy, or agreed to be paid to me for services rendered or to be rendered on behalf of the debtors, in the contemplation of or in connection with the bankruptcy case, is as follows. So this is a very important paragraph. It basically says that they are certifying, the attorney is certifying that this is the amount of compensation that the debtor agreed to pay within 1 year before filing the bankruptcy, or either has paid or agrees to be paid for the services rendered. So line 1, it doesn't say A, but it's the first box to fill out. It says, for legal services I've agreed to accept, and then you have to identify the amount. So in this case of George and Martha Washington, the Washingtons have agreed to pay their attorney $2,000 for the bankruptcy case. So let's include the $2,000. The next line says, prior to filing of this statement, I have received. So that means the debtor's attorney has to identify how much of the $2,000 of the legal fees that the debtor promised to pay were actually received prior to the case being filed. So again, the first line says how much in total will be paid by the debtor for the bankruptcy case. The second line says how much was received prior to filing the case. So in the case of George and Martha Washington, they have received the full $2,000. The next line says, what's the balance due? So that's a simple mathematical calculation. In this case, the Washingtons agreed to pay $2,000 to the attorney, and in fact, they already have paid $2,000 to the attorney, so the balance due would be 0. The next line is line 2. Line 2 makes the statement, the source of the compensation paid to me was. So that means that the debtor's counsel has to identify where the money came from for the debtor to pay the $2,000. So you have two choices. Either the debtor paid it or somebody else paid it. So if the debtor paid it, you check the box debtor. On the other hand, let's assume that the debtor didn't pay it and it came from the debtor's father, in which case you check the other box and then specify who that person was. And this would be an example of Jack Washington, which is George Washington's father, making the payment. But in the actual example of George and Martha Washington, the payment was paid by the debtors, in which case I'm going to uncheck the other box and I'm going to delete the payment made by Jack Washington and then check the debtor box. Again, on line 2, the source of the compensation paid to me was the debtor. Line 3 has the line, the source of compensation to be paid to me is. Now notice the difference between line 2 and line 3. One is it already has been paid, and the other one is what will be paid in the future. Line 2 is what has already been paid. Who made that payment? Line 3 is who will be making that payment in the future. In this case, there are no future payments because the payment was paid in full, so I wouldn't check either. But again, just like line 2, if there was a future payment to be made and it would be paid by the debtor, then I would check debtor. Or on the other hand, if the source of the future payment to be made would be someone else, I check the other box and identify the other person. So that would be the example. But again, in George and Martha Washington's case, the payment was paid in full, so there will be no future payments. So I would uncheck the box